This episode is brought to you by Shopify. Whether you're selling a little or a lot, Shopify helps you do your thing, however you cha-ching. From the launch your online shop stage, all the way to the we just hit 1 million orders stage. No matter what stage you're in, Shopify's there to help you grow. Sign up for a $1 per month trial period at shopify.com/special offer, all lowercase. That's shopify.com/special offer.
This ad-free podcast is part of your Slate Plus membership. Hi, and welcome back to Amicus. This is Slate's podcast about the courts and the law and the rule of law. I'm Dahlia Lithwick, and I cover that for Slate. Opinion Palooza is as Opinion Palooza does. This week saw the High Court drop a small mountain of cases, suggesting they may still manage to finish up the 2023 term by the end of June as intended, even though they are clearly reserving the great big doozy cases for the last few days of next week. I'm starting to think of it like as a constitutional dine and dash. They just run. On today's show, we are going to cover two of the most impactful decisions. One that we've been awaiting since November, another which might have flown under the radar, but for Justice Sotomayor's dissent. The first case is, of course, Rahimi, the case about whether adjudicated domestic violence abusers could possess firearms after the Supreme Court's expansion of the Second Amendment in Heller and Bruen. Friday, by an 8-1 margin, the court said no, and I'm going to go ahead and let you guess who the dissenter was. The other case is Department of State versus Munoz, a deep dive on whether Americans married to non-citizen spouses have a fundamental liberty interest in that spouse being admitted to the country. On Friday, the Supreme Court said no. In a dissent, Justice Sotomayor sent up a flare about the implications of that decision for the fundamental rights of married people, with a specific warning about the future of Obergefell. If you are a Slate Plus member, a brand new Cigar Bar bonus episode is ready for your listening pleasure. As soon as you finish this one, Mark Joseph Stern and I are going to be talking about a Thursday case more that raised the possibility of the Supreme Court vivisecting much of the tax code. And we're going to have a sidebar about the decision by the state of Louisiana to post the 10 Commandments in every classroom in the state, despite the fact that that would be unequivocally, irredeemably in violation of the Constitution. Oh, well. If you are not a Slate Plus member, you can sign up at slate.com/amicus plus, or you can just click try free at the top of our show page if you're listening in Apple Podcasts. So, United States versus Rahimi. We've been waiting on this opinion since November. And on Friday, the justices vomited forth 103 pages in which Chief Justice John Roberts, writing for an extremely fractured and fractious majority, painstakingly explained that the majority of the court are, to be sure, still gun nuts, CEG last week's bump stock debacle. But they are not, in fact, wedded unto death to the insane version of originalism that they adopted in their 2022 Bruen majority ruling. That was the one that reimagined justices as kind of roving costume reenactors of the founding, or just pretended that gun technology has been sealed in amber for all time since the musket. Joining us today to discuss how it came to this is Kelly Roskam, Director of Law and Policy at the Johns Hopkins Center for Gun Violence Solutions, as well as Mark Joseph Stern, who wrote on Friday, the Chief Justice's Rahimi opinion cut back Bruen at every turn. Some courts, the Chief Justice wrote, have misunderstood the methodology of our recent Second Amendment cases. These precedents were not meant to suggest a law trapped in amber, end quote. So, Kelly, welcome to the show.
Thank you so much for having me.
And Mark, welcome back.
So happy to be here, Dahlia.
And Kelly, I fear we're going to ask you to walk us through 2 centuries of Second Amendment law, if you would, just to get us all at the same table. There was one view of the Second Amendment that lasted kind of until the end of the 20th century, and then everything changed, and here we are. So do you mind just giving us a quick and dirty primer on how we got to where we got today?
No problem. So from the time of the ratification of the Constitution up until 2008, the Second Amendment was generally interpreted to be a collective militia-based right, not an individualized right for the purpose of self-defense. But that all changed when the Supreme Court issued its decision in District of Columbia versus Heller, in which they articulated for the first time that it did encompass an individual right to possess a handgun in the home for self-defense. 2 years later, they issued another opinion in McDonald versus City of Chicago, essentially expanding the scope of the Second Amendment to be applicable against the states through the 14th Amendment. What they didn't do in either Heller or McDonald was really clarify for lower courts how they were meant to evaluate future Second Amendment cases. And so in this analytical vacuum, lower courts coalesced unanimously around a 2-part test that first looked to history to determine whether the Second Amendment was implicated at all. And if so, then they applied some form of means-end scrutiny, asking how closely the law was related to achieving an important government interest. That reigned supreme for about 10 years until 2022, when the Supreme Court issued its decision in New York State Rifle and Pistol Association versus Bruen, where they abandoned this 2-part test in favor of a new 2-part test. So first, the court says it should be determined whether the plain text of the Second Amendment, which is, absolutely crystal clear, covers the conduct at issue. And if so, the government must show that the modern law is consistent with the national historical tradition of firearm regulation. And it says they can do that by analogizing these modern laws to historical firearms laws.
So, Mark, I guess in that little interregnum that Kelly just described, we had years and years of cases that the court didn't want to take. Clarence Thomas wanted them to take it, but they didn't want to take it because they didn't have 5 votes to do something insane. And then, as Kelly suggests, suddenly in Bruen, they did. And I would just love for you to sort of amplify, if you can, and I know it's challenging, what Kelly just said about how suddenly they get this over a century-old New York state law limiting the carrying of guns outside the home. And Justice Thomas, in his opinion, kind of turns it into there's a brand new test, but it's originalist. And as Kelly just said, now we're going to need analogies.
Yeah, and let's be clear about what specifically happened in that interregnum. Brett Kavanaugh replaced Anthony Kennedy. Amy Coney Barrett replaced Justice Ginsburg. Suddenly, there were 6 conservative justices who were ready to go whole hog on gun rights. And it was like their 21st birthday. They were pounding Jell-O shots. They were like, you know what? Let's give this to the craziest guy in the room because he's always up for a good time. And that guy was Clarence Thomas. And so the Chief Justice made a decision that I'm certain he came to regret very quickly, which was to assign the opinion in Bruen to Clarence Thomas, have him write for the court, which meant that the case became much more than just a question of whether you have a right to carry firearms outside the home. The court said, yes, you have this fundamental constitutional right to carry your guns outside the home. States basically have to give you a permit if they require permits at all. By the way, that is totally ahistorical and nonsensical. There were a ton of severe restrictions on the right to carry guns outside the home from 1791 all the way through 1868 and beyond. But set that aside, Clarence Thomas did what Kelly just described so well, which was to say, well, every gun regulation now, every restriction on the right to bear arms is presumptively unconstitutional and can only be salvaged in the courts if the government can find in the history books a sufficient number of these historical analogs that are very closely related, if not a mirror image, to the modern regulation. And if we can't find those, maybe they're out there, but the government doesn't have the time or resources to find them. Maybe the government doesn't have enough historical expertise to identify them. Maybe the courts are bad at interpreting history and don't understand them. Either way, if a court's not convinced that there's this pile of analogs and that they're a mirror of the law today, then the court has to strike down that gun restriction. And that unleashed 2 years of chaos on this country in the lower courts, where you had judges striking down laws, in this case, right, disarming domestic abusers. In other cases, prohibiting the obliteration of a serial number from a gun. A judge said, yep, that's a fundamental right to scratch the serial number off your gun. The right to possess guns while using illegal substances. The right to possess guns as a convicted felon. The right to bring guns into the post office and potentially other government buildings. I mean, the courts really went cuckoo with this stuff. And that's why Rahimi was so important, because it was an opportunity after the 21st birthday binge, after that rager, in the cold light of day, for some of the other conservative justices to say, maybe Clarence Thomas should not have been the designated driver here.
And Kelly, just a quick follow-up. Mark makes this point, but I think you've been watching it at a really granular level. Judges across the country now for 2 years since Bruen have been trying to figure out what the test is, and also trying to figure out what their job is, and trying to figure out what counts as a legitimate source. And I'm just really curious. I mean, Mark has kind of like ticked off now, like, here's some of the worst hits of, things that judges have had to invalidate in the wake of Bruen. But at a simpler level, what was the advice being given to people who are trying to draft gun regulations in view of the new, you need a perfect one-to-one analog test?
So that's actually been a really confusing and difficult piece of this, because at bottom level, legislators are still mainly interested in passing laws that are going to do good for their constituents. They want to know, is the law going to reduce firearm violence? Secondarily, they also want to know if it's going to satisfy this new Bruen framework. And as Mark so beautifully put it, courts are in just absolute confusion over this. They don't know what it means to be covered by the plain text of the Second Amendment. Are we only looking at the bare conduct of possession of a firearm, in which case that plain text step is kind of just a rubber stamp on all gun regulations, which touch on, surprise, surprise, guns? Does it also encompass who's included in the people? And how do we figure that out? Are we considering people's status at that plain text step, whether they're subject to protective orders, whether they've been convicted of felony offenses or misdemeanor offenses? What do we mean by arms? What does it mean to keep and to bear? Does that include sale? Does that include, training at the range? And then as we move into the historical analogies, the court kind of had this weird little passage in Bruen where it says, if a problem has persisted since the 18th century, the lack of distinctly similar historical laws cuts against the constitutionality of that. But if it's an unprecedented societal problem or some kind of unforeseen technological change, we're only looking for relevantly similar laws. So there's all kinds of unmoored discussions about what is a societal problem? Like, what makes it persistent or unprecedented, and at what level of generality are we looking? Thomas in Bruen basically says urban gun violence is the category of societal problem that we're looking at. And then again, how closely do these analogies have to fit? At some point, if, the purpose has to be identical and the mechanism has to be identical and the burden on the right has to be identical, we're really talking about identical historical laws rather than analogs.
And I want to just flag the obvious piece and the reason this case becomes I almost want to say the hinge for our entire originalism series that we did in May, is because you know what wasn't a problem at the founding? Domestic violence. And it's not that it wasn't a problem. It was a problem that was not considered a problem. And so, Kelly, if you could just do one beat in the fog of far distant history, the last 30 years of domestic violence protective orders and how we have come as a society to think that that which was not a problem to the founders is still very, very, very much a catastrophe. And there was a real problem that was trying to be redressed in the last decades.
Absolutely. And just as an aside, I want to say, intimate partner homicide at the founding was rare. Intimate partner homicide with firearms was even rarer. So it's not surprising that we don't have historical laws addressing armed abusers, even though interpersonal violence generally existed at the time. We've made enormous strides over the last 30 years addressing domestic violence, and particularly armed domestic violence. The law at issue in the case that we're talking about is 30 years old. In, sort of the 1970s and moving forward, states really started to adopt these protective orders as a way of addressing intimate partner violence. Increasingly, they added their own prohibitions on purchase and possession of firearms. More recently, they've been doing a much better job at ensuring relinquishment. So not just that you're not supposed to have it, but that there's some kind of infrastructure for ensuring that you give them up. And all of this has contributed to reductions in firearm intimate partner violence.
So, Mark, I guess this toxic stew of the incomprehensible test in Bruen, the domestic violence that has only been relatively recently redressed in the law, and that takes us to Zaki Rahimi, the star of the show. And I just want to know, Chief Justice Roberts writing the majority opinion today does the thing that the justices always do when they want to center a really bad guy behaving really badly. It did not have to go this way, but could you just tell us briefly about Zaki Rahimi and the really fun, good time he had with his gun, including the abuse of his domestic partner that led us to this case?
Yeah, so Zaki Rahimi is exactly the kind of person that any reasonable American would want to disarm, I think. And that's important to note because this is the first Second Amendment case the Supreme Court has taken up that is not a carefully manufactured test case by advocates, right? So in Heller and in McDonald and in Bruen, Second Amendment activists chose their plaintiffs carefully. Lovely, wonderful people, no history of violence, finessed the facts of the case, made them look like, people you would trust with a firearm, people who seem like they deserve access to firearms or shouldn't be disarmed by some arbitrary law. And the justices bought that framing. But after Bruen unleashed all this chaos, the Second Amendment really moved, I think, from the realm of conservative activists to the realm of public defenders, who are the people on the ground every single day dealing with these gun charges, trying to, as the Sixth Amendment requires, zealously defend their client by any means necessary. And after Bruen, that has increasingly meant arguing that a certain gun restriction is unconstitutional. And that's what Zaki Rahimi's lawyers did. And again, not blaming the public defenders. They are doing the best with the tools the Supreme Court gave them. But I think it gave a lot of justices the ick to see the real world consequences of their decisions in those carefully manufactured cases once this all got into the hands of the PDs. So Zaki Rahimi is a criminal, a violent criminal, and an abuser. He beat his girlfriend. He fired shots at either her or a witness who saw the abuse when she was trying to flee. She got a restraining order from a Texas court that found he posed a credible threat to her physical safety. He violated the restraining order. He continued harassing her. He then threatened a different woman with a firearm. He was the suspect in at least 5 additional shootings. The police eventually searched his apartment. They found, and Chief Justice Roberts writes this very archly, they found a pistol, a rifle, ammunition, and a copy of the restraining order against him. So he knew that he was not allowed to have those guns because there's a federal statute that says if you are subject to a restraining order for domestic violence and it requires a certain threshold of proof presented to a court, it requires a court to adjudicate a case and issue a restraining order. Once that has happened and you are the subject of it, you are no longer allowed to possess a firearm. Federal prosecutors charged Rahimi under that law. He challenged it, and the U.S. Court of Appeals for the Fifth Circuit, surprise, surprise, found that the law was entirely unconstitutional, struck it down, and forced, I think, the Supreme Court's hand on this one because SCOTUS was not going to stand idly by while the Fifth Circuit granted domestic abusers in this country a newfound right to bear arms that they will inevitably use to murder their partners and children.
We are going to pause now for a moment to hear from our sponsors.
It's hard to imagine a world where we leave future generations with fewer rights and freedoms. The Supreme Court has stolen the constitutional right to control our bodies. Now politicians in nearly every state have introduced bills that would block people from getting the essential sexual and reproductive care they need, including abortion. Planned Parenthood believes everyone deserves access to care. It's a human right. We won't give up and we won't back down. Help ensure the next generation can decide their own futures. Donate to Planned Parenthood. Visit plannedparenthood.org/future.
This episode is brought to you by ZBiotics. There's now a game-changing product to use before a night out with drinks. It's called ZBiotics. Let's face it, after a night with drinks, it's tough to bounce back the next day. You have to make a choice. You can either have a great night or a great next day. ZBiotics is a surefire way to wake up feeling fresh after a night of drinking. ZBiotics Pre-Alcohol Probiotic Drink is the world's first genetically engineered probiotic. It was invented by PhD scientists to tackle rough mornings after drinking. Here's how it works. When you drink, alcohol gets converted into a toxic byproduct in the gut. It's this byproduct, not dehydration, that's to blame for your rough next day. ZBiotics produces an enzyme to break this byproduct down. Just remember to make ZBiotics your first drink of the night, drink responsibly, and you'll feel your best tomorrow. Go to zbiotics.com/amicus to get 15% off your first order when you use Amicus at checkout. ZBiotics is backed with a 100% money-back guarantee, so if you're unsatisfied for any reason, they'll refund your money, no questions asked. Remember to head to zbiotics.com/amicus and use the code amicus at checkout for 15% off. More now on the Supreme Court's all-new, not-so-new Second Amendment doctrine with Mark Joseph Stern and Kelly Roskam from the John Hopkins Center for Gun Violence Solutions. I read the Chief Justice's opinion. It kind of reads to me like when my son would do an essay and go to turn it in, and then I would like rewrite it for him and just be like, oh, he doesn't mean to say that. Like he's essentially bottom up rewriting Bruen. But he can't say Bruen was crazy, super sad, I assigned it to Thomas, super sad, we all signed on, look at the pickle we're in. So what he has to say is, this is kind of sort of what Bruen said all along. This essay was superb, and I'm not rewriting it at all. And yet, the opinion in Rahimi on Friday fundamentally changes the test that was set forth in Bruen. And the fact that Thomas writes pages and pages and pages of a dissent suggests that he really thought his essay was really good in the first instance. So I would love for you to explain now what the new test is and what it is that John Roberts did to both salvage Bruen and also to completely cabinet.
Yeah, I mean, you're right. Robert's majority opinion really has a dad coming in to clean up vibe. And Thomas's dissent is like the toddler throwing the tantrum a little bit. What Roberts is saying, again, is we're not admitting that we made any mistakes. And we're not saying that we're changing the framework. You know, we're saying, lower courts, you've misinterpreted what we were trying to say in Bruen. And so I'll try to set the record straight. So he reiterates some of this language that's found in Bruen that says that historical analogies, we're not requiring historical twins or dead ringers. This is not a regulatory straitjacket. We were really serious when we said that the analogies could be a little more flexible. And he says what we're looking for are the animating principles behind the Second Amendment. That, we're not, creating law trapped in amber, as it were, and that the historical record is clear that the nation's firearms laws have always allowed preventing individuals who threaten physical harm to others to be disarmed. Now, it's less clear to me how flexible these general principles are. We're not trapped in amber, but are we still in the sticky sap?
Can I just add a line that I love from the opinion where the chief says, as we explained in Bruen, the appropriate analysis involves considering whether the challenged regulation is consistent with the principles that underpin our regulatory tradition. Okay, that is not actually what you said in Bruen, at all. And the only way that you can claim that is in the following sentences, chopping up pieces of Bruen and then plucking them out and plugging them into new sentences, as if you ran Bruen through ChatGPT with the instruction to make it 67% less crazy. That is what the majority opinion very much reads like to me. And I love where he lands. The big conclusion here, as Kelly indicated, was, I'll quote again, an individual found by a court to pose a credible threat to the physical safety of another may be temporarily disarmed consistent with the Second Amendment. Great. Love that for you, John Roberts. Love that for us. But that is not even remotely a fit with the Bruen test, as Clarence Thomas points out in his solo dissent. I mean, there's all this history that Roberts kind of breezes through at a very, very high level of generality that Clarence Thomas digs down into. And I hate to give it to Clarence Thomas, but I think he's clearly correct that there are no great analogies between this law at issue and the laws from the 17 and 1800s. They're obsessed with these surety laws, which was this thing where if you were suspected of being a future criminal, you could go to court and put down money like a bond. And then if you violated the guarantee that you wouldn't be a criminal, then the bond would be forfeited. And for Roberts, that's enough. This weird, archaic civil system is enough to justify a modern criminal prohibition on firearm possession. And as Thomas says correctly, these are very much apples and oranges. And even at Roberts' high level of generality, I'm not convinced that his holding follows from his articulation of the test, which, again, I want to be clear, is fine by me. I'm very glad that Roberts erred on the side of gun safety and deferring to the government and its experts. But he says here, even when a law regulates arms bearing for a permissible reason, it may not be compatible with the right if it does so to an extent beyond what was done at the founding. Well, that's this law. This law regulates dangerous people beyond what was done at the founding. There is not a single analogy from 1791 or thereabouts when the government imposed a criminal prohibition on the possession of firearms for someone adjudged to be a domestic abuser. Now, there are a bunch of reasons why, because women were not equal citizens, women did not have equal rights, all the reasons that Kelly listed earlier. But still, it's you can't really line up Thomas's articulation of the test and Thomas's holding and get a perfect fit. And that's because there's so much cleanup to be done here, cleanup on Isle Bruen, that the final product doesn't quite make sense as the work of a judicial opinion.
I can't agree more. When you look at the way Bruen conducted its historical analysis, where it kind of lines up these discrete historical laws like dominoes and says, well, this is a little bit different, so, it doesn't count. And this is a little bit different, and it doesn't count. And this is from the territories, and it doesn't count. Versus this, which is taking, I think, a broader, more holistic view of groupings of historical laws to evince these broader purposes, which I am also completely fine with. This makes so much more sense for evaluating the Constitution. It makes more sense for the policy purposes that these laws are put to. But it is a lot different from the way they handled analogies in Bruen.
Mark, can you just give us a quick second, if you would? There's a lot of opinion writing in this opinion. There's a lot of people weighing in some sense, to do the cleanup work you both just indicated had to happen, but also a little bit of puffery, oh, I never meant to be, that. Can you tell us what some of the concurrences say?
Yeah, so we'll start with the liberals, which I think are really interesting because Justice Sotomayor, joined by Justice Kagan, has this concurrence saying, yes, this is an excellent application of Bruen. Definitely what Bruen meant. No question there. By the way, Bruen was clearly wrong. Our entire Second Amendment jurisprudence has gone terribly off the rails. And the approach that the lower courts have taken under Bruen is chaotic and lethal and terrifying. I would call it sort of a victory lap, sort of a celebration of the majority's walk back of Bruen. Sotomayor could have come in and pointed to the majority and said, you guys couldn't even stand by your own work product from 2 years ago because it's so embarrassingly bad and sloppy. She didn't do that. Although Justice Ketanji Brown Jackson sort of did. Justice Jackson came in with a separate concurrence, reiterating some of those basic points from Justice Sotomayor, but going farther to say that, what the lower courts are doing is madness, but we really only have ourselves to blame for that because we gave them an unworkable and wacky test that cannot be applied with any consistency or clarity. And ultimately, who suffers here is the people who have to live under our rule when we've decided that we will be the arbiters of gun policy for the entire country. Really strong opinion, as usual, from Justice Jackson. The conservatives are more of a mixed bag. So you have Justice Gorsuch saying that the challenge here was basically too broad, that Rahimi shouldn't have challenged this entire federal statute, but just its application. But even then, that its application to him is constitutional. He's kind of like in a compromise mode here. Justice Kavanaugh's more interesting because he arguably kind of invented the test that was used in Bruen. When he was on the DC circuit as a lower court judge, he proposed this text, history, and tradition test. And so he devotes much of his concurrence in Rahimi to trying to defend it and also injecting precedent into it, which is wow, what a concept. We're actually going to look at what the court has previously said when deciding what the court should say now, and acknowledges that it's not a perfect test, but still says it's better than the alternatives. 0 points to Brett, in my opinion. This was not an effective concurrence. A handful of points to Justice Barrett. Amy Coney Barrett has a pretty interesting concurrence where she says, look, Bruen demands a wider lens than the Fifth Circuit deployed, that historical regulations reveal a principle, not a mold, and that we aren't locked into late 18th century policy choices. So she's saying, look, this is originalism. I'm still doing originalism, but my originalism isn't as cuckoo as what Clarence is doing over there in his dissent, and trying to pull some kind of practicable, and neutral principles out of this originalist muck. Whether she succeeds or not, TBD, but it's at least an admirable effort. And I guess that just sort of leaves us with Clarence Thomas, who's the only one willing to stand up and stand by his own work from the past and say, yes, we should be arming domestic abusers in this country because they have a right to own guns.
So that leads me to the data, because I want to be really clear. This is not a win. This is a not loss. This is pruning back the worst of Bruen without really doing much, I think, to help the catastrophic gun violence in the country. Last year, more than 40,000 people killed by guns in the United States. Gun violence is the #1 killer of children in America now. Every month, about 70 American women murdered by gun-wielding intimate partners. If her abuser has a gun, an abused woman, we talked about this at oral argument, is 5 times more likely to be killed by that partner. Help me know 2 things now, Kelly. What does this change going forward in terms of what can be put into place? What can be bolstered? What do we know? I mean, does this literally mean that every single domestic violence law that was in the crosshairs, so to speak, is now safe? What do we know about what we need to do to begin to stop this just unbelievable American scourge of gun violence, particularly against women?
There's a lot that we need to do. I mean, I want to say when the opinion came out on Friday morning, I was incredibly relieved, but the bar is really low. If it had come out any other way, I think it would be absolutely devastating, and I don't think the Supreme Court gets any brownie points for doing the right thing here. What it did not do very specifically and very carefully was to say anything about an additional provision of the law at issue. So the federal law prohibits people subject to these protective orders that are issued after notice and hearing against intimate partners, where there is either a credible finding of threat to that intimate partner or child, or that its terms explicitly prohibit certain types of activity. So what the court absolutely did not say was that it is upholding orders where there is no credible finding of threat. That, I think, will percolate up through the courts. I believe there's already a district court case about that particular provision of the law. What it also did not discuss are these ex parte or emergency protective orders. So often when individuals get protective orders, they first get an emergency order that is issued against a respondent before they are given notice, before they have the opportunity to participate in a hearing. It's often the most dangerous time for individuals because it's the first indication that an abuser is losing control over that individual. Many states across the nation also prohibit purchase and possession of firearms during that ex parte protective order period. So we're likely to see cases regarding that as well. I think that this is indicative that extreme risk protection orders, sometimes called red flag laws, at least in applications where the risk is of harm to others, are on safe constitutional ground. Less clear is where the orders are issued because of risk of self-harm, though the court repeatedly refers to prohibitions on persons with mental illness. And I think, apart from the constitutional aspect of this, implementation is incredibly important. It's great to have the law prohibiting purchase and possession, but we need everybody who's involved in that process to do their job. We need everybody to know exactly what to do. We need follow-up. We need to ensure compliance to really effectuate the promise of this protection.
I guess I'm going to just take one little moment to spike the football and say, whatever originalism is, I don't know what this is, but holy cow, whatever Bruen held out to be originalism, which is this locked in history, incredibly crabbed view, reinstantiating everything that is wrong about the founding and forcing judges to do nothing but become historians and cherry pick history, feels like kind of a win for the idea that that was all a very bad idea. Mark, I'll ask you and then I'll ask Kelly, is there some glimmer of hope, not just from the fact that every justice but Clarence Thomas backed off that incredibly, I think, punitive, dangerous view of originalism that we saw set forth in Bruen, but also that something about looking, instead of for matching analogs, for matching historical principles at that level of utter abstraction means that judges can now go back to doing whatever it was that they did until the 1990s when originalism became a thing?
With regard to the Second Amendment, I think it's going to be a real mixed bag. I think it's still going to be a choose-your-own-adventure situation in the lower courts where the Fifth Circuit is probably not going to take the hint. The Fifth Circuit is going to continue to churn out extremist decisions affirming a sweeping right to bear arms, specifically for its favored parties, and need to be reeled back in by the Supreme Court. One of the first things that's going to happen now that Rahimi is out is that the court's going to take up a bunch of lower court decisions on the Second Amendment and vacate them and send them back down for reconsideration in light of Rahimi. So we're about to get a spate of second bites at the apple from the lower courts trying to apply this. And even though I'm grateful for what the Chief Justice did, and I'm glad that they have walked back the kooky extremism of Bruen, there's still so many questions that Kelly was pointing toward that just are not answered in this decision. What about ex parte orders? What about red flag laws? What about self-harm, mental illness? Even in this relatively narrow category of potentially violent gun owners, there's a lot we still don't know. The courts are going to splinter, and the Supreme Court's going to have to come back and provide an answer, and then another, and another, and the court's going to stay stuck in this Second Amendment area where, as I think we proved in our originalism podcast, Dahlia, they have no right to be in the first place. There's no legitimate justification for the Supreme Court to repeal the first sentence of the Second Amendment and transform a clause about the state militias being preserved after the ratification of the Constitution into this freewheeling, policy-driven right of individuals to keep and bear and travel with and use arms in self-defense. So this doesn't solve the underlying problem. It closes one can of worms. Can you close a can of worms once it's open? It closes one can of worms and opens a bunch more. And so I don't think that this will be all she wrote when it comes to guns and originalism. In other areas, who knows? What I hope is that the court is so chastened by its experiment with originalism here that it won't be overly aggressive in pushing originalism into other areas. And that was what Justice Barrett was hinting at in her opinion in that trademark case recently, where she splintered from the other conservatives and said, look, we already have an established First Amendment framework. We don't need to reinvent the wheel here and create some new kind of history and tradition test for free speech. I hope that Barrett has at least one more vote from the right in similar cases. But, Justice Kavanaugh spent many, many pages talking about why every other test is bogus and history and tradition is the only one that matters. So I'm not sure that a majority of the majority got the message it should have from Bruen's fallout.
Kelly, I want to ask you kind of the same question in a different way, but we started this term saying that originalism, as constituted in Justice Thomas's vision of the Bruen opinion, would not withstand one Zaki Rahimi. We just walked into the term saying, this guy, no. And I think Mark has just said, and it's true, that's true for purposes of this Supreme Court. It is not at all clear that that's true for the Fifth Circuit or the other courts around the country who really, really want to take us back to the founding, not just principles, but founding law. And so I guess I find myself wondering, do you see this as a triumph of kind of a large-scale renunciation of a really bad idea, or simply the Supreme Court kind of embarrassed that it pounced itself 2 years ago, wanting to not look stupid, but in some sense, the train has left the station because there are judges and courts around the country who don't care what the Supreme Court thinks anymore?
So on the Supreme Court's part, I don't think this is some massive renunciation of Bruen's framework. I think the facts of the Rahimi case are sort of the sword that cuts both ways. It was so bad that I think it was hard to conceive of the case coming out any other way than it did on Friday. But as, Justice Barrett and several others at oral argument kept repeating that this was so far in the heartland, everybody agreed he was clearly dangerous. He was the kind of person that shouldn't have a gun. Even the Fifth Circuit, in striking down the law, basically said they wouldn't want to either, but they felt like they had to. That other cases, I think, are going to be a little bit closer. I mean, again, I think this sort of stems the massive flow from the dam, but didn't provide any real clarity for other courts on how to find these general principles, what level of generality we're actually talking about in finding them. It's clear that there's this historical tradition of disarming people who judges have found are a credible threat to the physical safety of other people. But what does that mean for other contexts about how to sort of piece together these analogs to find a greater purpose, which means there's still so much opportunity for subjectivity all over every single substep of this test, which I think really flies in the face of what we were told in Bruen, which is that this is so much more objective, so much more administrable than means-end scrutiny. But I think it's much more open to interpretation and, personal preference on the part of judges.
Kelly, thank you so much for joining us so quickly after you had to swallow down a very bulky 103 pages of Rahimi opinion. Kelly Roskam is Director of Law and Policy at the Johns Hopkins Center for Gun Violence Solutions. Thank you, Kelly.
Thanks so much for having me.
Mark, don't go anywhere. You are going to hang around and talk about another big decision that came down on Friday, State Department versus Munoz, that elicited dissent from Justice Sotomayor that would be a 3-4 alarm fire, 5 alarm fire, big old fire warning regarding the future of Obergefell and marriage equality. We're going to be right back for that after these words from our sponsors.
Hi, Amicus listeners. Today's episode is brought to you by Grave Injustice. This narrative series podcast, hosted by Lisa Graves, tracks the right-wing takeover of the U.S. Supreme Court. Each episode is like a history lesson that goes beyond the cases the court heard this term to explain the right-wing agenda behind them. Grave Injustice names names. From Leonard Leo to Charles Koch to the web of dark money organizations behind this extreme agenda to reshape American society through the courts. All 5 episodes of the first season of Grave Injustice are out now. Listen wherever you get your podcasts.
This episode is brought to you by Shopify. Whether you're selling a little or a lot, Shopify helps you do your thing, however you cha-ching. From the launch your online shop stage, all the way to the we just hit 1 million orders stage. No matter what stage you're in, Shopify's there to help you grow. Sign up for a $1 per month trial period at shopify.com/special offer, all lowercase. That's shopify.com/special offer.
Welcome back. As promised before the break, I wanted to turn to a case that didn't get much attention, both this term maybe and on Friday. That's State Department versus Munoz. It kind of looks like it's a case about immigration law and about the rights of folks who are married to non-citizens. And yet it's also, as Justice Sotomayor signals in a dissent here, kind of a case about marriage. So can you just talk briefly about what this case is about on its own terms? Set the stage. What are the facts?
So Sandra Munoz is an American citizen. She's married to Luis Asensio Cordero, who is a citizen of El Salvador. They have a child together who is an American citizen. And she, Sandra Munoz, wants to sponsor her husband to come to the United States on a visa. The United States denied that visa and also refused to tell her why it had denied that visa for her husband. She sued and prevailed in the 9th U.S. Circuit Court of Appeals, which held that the Constitution creates a liberty interest for individuals to live in the United States with their spouses, that what the government did here intruded on that constitutional freedom, and that the government, at a bare minimum, therefore had an obligation to give Sandra Munoz a reason for denying her spouse's visa, which she could then theoretically use to try to contest that denial.
Okay, so I guess the follow-on question is, how does the majority change this into kind of an arrow aimed straight at the heart of marriage rights?
The majority has a couple moves. First, the majority rules against Munoz. Let's be clear. This is a total loss for her. And it says, no, you do not have a right to be given the reason for your spouse's visa denial. The majority could have stopped there, but it didn't. Instead, it declared for the first time ever that there is, in fact, no liberty interest under the Constitution for spouses to live together in the United States, no constitutional liberty for an individual to sponsor and bring over their non-citizen spouse to live with them and their family in the United States. And so the entire case was essentially frivolous because no fundamental right has been implicated. Sandra Munoz never had any kind of liberty interest in bringing her husband over. So the State Department here really could have done whatever it wanted to his visa, denied it without a reason, denied it without saying another word, because there's no constitutional right at play.
And for those of us who actually thought in the spirit of originalism that marriage rights were actually pretty foundational and pretty established, I think one of the things you're saying is the court didn't even need to get to this discussion of marital rights. Justice Gorsuch has a concurrence, un-Gorsuchy, saying they didn't need to get this far.
That's exactly right, because, the government has already given her the reason. The government claimed falsely, but, we can deal with that her husband had gang symbols as tattoos. Now, he has a gang expert who testifies that it's untrue, that these are tattoos that many Latin American men have. But at a minimum, the government has already said we're denying his visa because we think he's in a gang, okay? That's the reason. Her case, at least her appeal here, should therefore be over. And Gorsuch says, I don't understand why the majority decides to keep going when we should have just sent this case back down. Ms. Munoz has gotten the relief that she sought, but the majority was hungry to go further. This is what Justice Sotomayor says in her dissent, and I think she's clearly right. The majority decided it wanted to cut back on the constitutional right to marry, and so it weaponized this case as a cudgel against that right, rather than doing the judicially restrained thing, issue a minimalist decision like Gorsuch suggested, and go along its merry way.
Let's walk through the Sotomayor dissent, please, because it's elegiac for something that isn't gone. And she starts right out the chute. The right to marry is fundamental as a matter of history and tradition. She quotes Obergefell. So there you go. History and tradition, Obergefell. She feels like the majority is doing something to imperil Obergefell, and that it's making a promise, that it's breaking a promise that it made in the Dobbs decision. What is she mourning, and what is she worried about?
She is preemptively mourning Obergefell and suggests that it will be the next casualty of Dobbs. And she points out that in Dobbs, in fact, the majority said that it was not undermining the right to marry, the right to reside with relatives, and the right to make decisions about the education of one's children. This decision on Friday undermines all of those rights. It takes away an individual's right to ensure that they are living with their spouse and with their children here in the United States. And in doing so, I think sabotages one of the key aspects of the court's marriage rulings. You know, she talks about how Jim Obergefell and his husband, they could have gotten married in Maryland and stayed in Maryland and stayed married, but they didn't want to. They wanted to go back home to Ohio and live together there. And so when the court struck down same-sex marriage bans, it specifically said that same-sex couples had the right to get married and to have their marriage recognized so they could live together in whatever state they wanted. Similar thing in Loving versus Virginia from 1967. The Lovings could have gone to D.C., gotten married, and stayed married in D.C., where their marriage was lawful. They didn't want to. They wanted to go back home to Virginia and live as a married couple in Virginia. The state wouldn't let them, and so the Supreme Court struck down the Virginia ban on interracial marriage. And Sotomayor says those principles are enshrined and ingrained in our marriage precedents. She cites them over and over again to send up this flare. She says it's not just about the right to have this piece of paper. It's about all of the accompanying rights, the constellation of liberties that have always come with marriage. And one of them is to live together. And she also points out that the majority's new rule is going to have a crushingly disproportionate burden on same-sex couples. Why? Because the majority says, well, if Sandra Munoz doesn't like living in the United States without her husband, she can just go to El Salvador. But for many, many same-sex couples, the non-citizen lives in a place where marriage equality isn't legal and where homosexuality might even be criminalized. And so she says this is discriminating against same-sex couples. It is telling them that if they want to live together after getting married, if one is not a U.S. citizen, they might have to go reside in a country where their marriage is not recognized or their existence is deemed illegal. Sotomayor does not whip out this rhetoric for a kind of low-level case. She is being very clear that the majority has reached far beyond the facts at issue here in order to call into question some of the bedrock principles of the court's marriage litigation, to say this right that we described as so fundamental and deeply ingrained just a few years ago, barely a decade ago, we're reconsidering that. We are very much open to changing our minds. And in fact, we've changed our minds about one aspect of it already.
It's so interesting because it really does raise all the questions we talked about after Dobbs about what substantive due process was meant to protect, right? How families work, how marriages work, where you live, the ability to travel together. It's stunning that Sotomayor is so upset about this and in these explicit terms, and it does raise the question that is always raised when you get a lone dissent that's not really about what the opinion is about in some sense. Is she just overreacting?
I don't think she's overreacting, because it is all too easy to imagine an opinion in a few years overruling Obergefell that cites the majority opinion by Justice Amy Coney Barrett in this case, in Munoz, right? The majority could so easily say just down the road, well, we already cut back some of the extravagant rights we purported to guarantee in Obergefell. This is just the next logical step. And I think that's why she also hinges her dissent on Dobbs, because there were all those false assurances in Dobbs that the court would go this far but no further. We all knew that was bogus at the time. We are seeing the falsity of it play out before our eyes. I do not think that Justice Sotomayor is overreacting. I think if she were, that Justice Kagan and Justice Jackson wouldn't have signed on. But they are right. They are with her, ringing this alarm so that everybody can hear equal marriage rights are on the table at the Supreme Court.
It's making me realize that there's a through line both in Rahimi and in Munoz, which is nobody knows what's settled anymore. Nobody knows what's precedent. Nobody knows what the test is. And nobody knows what's coming next. And that level of acute uncertainty within the law itself, not just on the court, is the thing that is so destabilizing for the justices, even as between their relationships amongst themselves and with the law itself. It's really like this level of anxiety about what's coming next is just not something I remember. Mark Joseph Stern covers the courts and the law and all the things. Thank you, Mark.
Thanks, Dahlia.
That is a wrap for this episode of Amicus. Slate Plus listeners, we will see you on the other side in our Amicus Plus episode, an opinion palooza tree fort special, all about the IRS, fake plaintiffs, a win for original flavor originalism, and the Christian right setting up for a big swing at the Establishment Clause via a thoroughly unconstitutional law just enacted in Louisiana. If you are not a Slate Plus member, but you'd like to hear that conversation, you can subscribe now on Apple Podcasts by clicking Try Free at the top of our show page, or you can visit slate.com/Amicus Plus to get access wherever you listen. The episode is available for you to listen right now. We'll see you there. Thank you so much for listening in, and thank you so much for your letters and your questions, particularly as this endless term rolls on. You can keep in touch at amicus@slate.com, or you can find us at facebook.com/Amicus Podcast. Sarah Birmingham is Amicus's senior producer with help from Patrick Fort. Alicia Montgomery is vice president of audio at Slate. Susan Matthews is Slate's executive editor, and Ben Richmond is our senior director of operations. We will be back with another, at least one, maybe more, episode of Amicus next week. Until then, thank you for coming along for this wild opinion palooza rodeo with us, and hang on in there.
This is the story of the one. As head of maintenance at a concert hall, he knows the show must always go on. That's why he works behind the scenes, ensuring every light is working, the HVAC is humming, and his facility shines. With Grainger's supplies and solutions for every challenge he faces, plus 24/7 customer support, his venue never misses a beat. Call quickgrainger.com or just stop by. Grainger, for the ones who get it done.